Hey, everybody. Are we here? We're here. I hope I got this set up right. Thanks for joining me for my first YouTube live stream. I'm hoping we don't have too many technical difficulties. You need to mute your microphone. I'm going to mute mine if my dog keeps barking, because she always does every time I start a broadcast. Anybody that's watching my videos knows every time I start, Justice barks without fail. She knows, she senses it. Anyway, so what's going on is that I actually have Angie on with me. And since I don't have multiple screens, I'm going to have to, Angie's going to handle the comments for me, or the questions for me. So if you have any questions, if it's about what I'm currently talking about, go ahead and ask, and she can just interrupt me. If it's something that isn't about exactly what I'm talking about, you might want to wait till the end to see if I get to it first before you ask. Otherwise, just at the end, I'll be asking if anybody has any questions, and you can take care of it then too. Whatever, however you want to do it. I just know that if you ask something and Angie asks me and I'm on a different topic, I'm going to just go off on a tangent, and then we're all going to be in trouble. So anyway, so time to get started. First off, I have to give a really big thank you to Eric Jose, because I would not have known how to do this if he hadn't done the video on how to do the Google Hangouts videos for the live stream. I would not have been able to add Angie. So thank you for that. Second, thank you to Angie for agreeing to handle the comments for me and take care of that for me. And she'll also be moderating the chat. And also I have Jamie here moderating the chat as well. The rules of the chat are just your common decency rules. Just don't be a jerk to me, to the admins, or to any of the people in the chat, and you should be good. That's all I ask. Just be respectful to everybody else. Now, what I'm planning on discussing today, I know I've done other videos in my group. I decided to do this one as a YouTube video because everything I'm discussing today is something that's really been covered in my group for over the last few days. It's been kind of all over the place because there've been a lot of posts, and so I've been answering in different threads, and so even people in my group might not have seen all the responses. But since everything was kind of already covered in my group, I figured it was a good time to test out the YouTube live streaming, just to see how it worked, if I liked it, how many people responded to it. That was really it. I figured this was a good time to gauge it when I'm not really giving anything really necessarily all that new. My plan is to discuss the motion again. And my last video was very case law heavy. It was very citation heavy. So I know I was reading a lot, and it might not have been for everybody, and I understand it if it's not, because I know it can be really boring for some people, or it's hard to follow. This time I want to try to talk more in, the plain speak, to really make sure people understand this, because I thought everyone had kind of a good handle on it, but then based on the questions I've been seeing over the last couple of days, people still really are not understanding the statute at all. So I want to try to explain it as clearly as I could so that everybody could understand it, what is being argued, how it applies to the statute, how it applies to case law. Again, not getting into the case law other than very generally. I'm not doing all the citations again, so you don't have to worry about that. And then I want to talk about something I posted in my group that is what kind of kicked this all off. And it had to do with the Avery bill and its effect on the current preservation statute. And so I'm just going to talk about a little bit about that, about exactly what I was posting, why, what it changed, why it changed, anything about that. I want to discuss some of the possible arguments the state could be making in their response. We still do not have it. Unfortunately, the administrative offices of the Court of Appeals was closed today due to the cold. It's about -20 degrees here right now. It's supposed to get colder tonight. So just about everything was closed. Now, they only said they were closed for today. The courts, a lot of the courts are closed tomorrow as well. But last I checked, the the clerk of court office was still only closed today. So hopefully they'll be back open tomorrow, and then we can actually see this response. I swear they did this to us just to keep us in suspense. But I'm gonna just kind of throw out some things that could be possible, and then I'm gonna cover the reasons why the court could deny it and why they should grant it. I'm gonna go over some of those things. Then I really want to go through the steps, the next steps, what needs to happen. Okay. Mainly because I had posted this in my group yesterday in response to the fact that somebody had tweeted that Steve was being released in 30 days, and that is not true. And I know that that person kind of got ganged up on a lot. And I've talked to her. I talked to Chuck right away because I wanted to find out what the heck he said. So, it was not meant to be malicious in any way. She didn't mean any harm, and she feels very badly about it. So, people make mistakes, and I don't want anybody to be beating up on that person for it. It just happens. But because of that, I went through the steps of what is going to happen next and how long it could possibly take. So I'll talk a little bit about that. And then at the end, I'm going to talk a little bit about what could potentially happen. I've talked about whether they will grant the remand, whether a hearing should be granted. I really haven't talked about what I think can happen after that, whether he can win or not, what it means, and really even how a loss can still be a victory, which I think is kind of important. So I want to point that out. So that's about it. So are there any questions before I get started? But if it's about any of those topics, wait till I get to. But if there are any questions before I get started, then go ahead and ask quick. And again, I can't see the chat. I know when I did, when I watched Eric Jose, sorry. I don't know if I'm supposed to say his name. Sorry, he'll be watching this and he'll be yelling at me. Eric Jose. I know he said he has multiple screens and that's how he can do it. I do not have that. So it would be nice, but I can't actually see the chat as I'm broadcasting. So that's why I have Angie and Jamie to keep an eye on things for me. Okay, so I'm just going to get started. Okay, so what exactly is Kathleen arguing? Okay, so we all know it's about the bones. Okay, now she filed this, and some of this is going to be a little bit repetitive, but bear with me because again, I think it'll be beneficial even if you've heard some of this, because I'm going to try to make it as clear as possible. Not always easy when it comes to the law, but I'm going to try. Kathleen is presenting arguments under two different areas of law. And she's saying that Steve's civil rights have been violated under statutory law, under the state statutes, which is created by the legislature, and under clearly established case law, which is the law that is created by the judiciary. Okay, so these are two separate areas of law, and she is arguing under them both. It's an either or type of situation. She can win on a statutory violation. She can win on a violation of on established case law. So either one is fine. Okay. Okay, so the first part we're going to talk about is the statute, because this is where all the confusion is coming in too. Okay, right now. I'm going to talk about the first part. Well, I keep 968-205-2, okay, is the statute that governs what law enforcement is required to keep by law. There are two separate parts to that statute. Okay, so even though it's all under sub B or sub 2, it's really two parts. And it says that they have to preserve any biological material that was collected during the course of a criminal investigation that led to conviction that is from the victim. That's the first part. And this is where a lot of confusion is coming in. Okay, when they say that it's from the victim, that means that it is definitely verifiable as belonging to the victim. It is not that it possibly could be suspected to be inferred that it could be. That doesn't fall under the letter of the law. Statutes are letter of the law laws, rules. So you can't just say, well, they were at least suspected, that should count. No, it doesn't. That's not how statutes work. That's where when you're talking about a gray area within the law, when you want some latitude, that's where case law comes in, and that's why you want it to fall under the case law. Okay. The second part of the statute, but that's not where it ends. The second part of the statute says that they also have to preserve anything that could be reasonably believed to have the ability to incriminate or exculpate, meaning exonerate, essentially, a person of the crime. Okay, so that's the part of the statute that Kathleen is looking to win under more than part one, because she knows that it's not identifiable to the victim. Okay, so she's trying to establish that under part two is where they violated Steve's civil rights. And essentially the question is, was it reasonable for law enforcement to dispose of the bones when they knew the identity of the bones was important to the defense? Now, the bones in the quarry were not the central part of the defense's case in chief. Obviously, that was the whole misconduct, planting of evidence. That was their central focus on the defense. But the defense very clearly asked questions trying to determine the identity of the bones, or even if they were just human. They tried to make a connection between those bones and the bones that were found in the burn pit. Okay. They also suggested that if those bones that were in the quarry were identified as Teresa's, that essentially would destroy the state's case, because their entire narrative was based around Teresa not leaving the property. And if they could call that narrative into question, the state would have had to change their entire theory of what happened at trial. Okay, so that's what she's trying to say under that part of the law. She's just saying, like, these guys should have known. They should have known that it was reasonable for them to think that it had exculpatory value, or at least probative value, because of the fact that this was an important thing to them during the trial. It doesn't have to be the focal point of it, but clearly it was an avenue that they wanted to explore further. And unfortunately, the testing at the time did not give them the results that would have been beneficial to Steve. That does not mean that they could not give beneficial results later on. And when you're talking about somebody like Norm Gahn, who was a prosecutor on the case and also happens to be one of the people that wrote this preservation statute, or sat on the board to write this preservation statute, he clearly knows the importance of scientific advances when it comes to technology and testing for DNA. He can't claim ignorance. This is the man that pioneered it for this state. Okay, he was the first one to actually start using DNA to prosecute crimes. So there's no way he can claim ignorance here, like, well, we didn't think that this could be exculpatory. I mean, obviously he can say it, but come on. Like, at least don't insult our intelligence when you're making an argument. Okay, so that's if she wants to win under the statute. Case law is a little more complicated, okay? But again, I'm not going to go into it too much. I don't want to confuse anybody. But essentially, the U.S. Supreme Court had two cases that established the criteria of what we base whether law enforcement had the right to dispose of evidence on. The first case was Trombetta. And under Trombetta, they just said that it's a due process violation if law enforcement disposed of evidence that was apparently exculpatory. Okay, that means that it was pretty obvious. It's a no-brainer that it could have exculpated the person. That would be just like the pubic hair in the first case. Okay, clearly a pubic hair that was not belonging to the victim in a rape case is apparently exculpatory. Okay, there's no way to argue that it's not. So in that case, that evidence would have fallen under Trombetta. Okay. After they decided Trombetta, they decided Youngblood. And this is what Kathleen puts in the beginning of the motion. In Youngblood, they changed the standard. Well, they didn't really change it. That's the one thing the Supreme Court didn't do. They never said that Youngblood supersedes Trombetta. They never really made it clear. Okay, so in Youngblood, they said that now the evidence could be just potentially exculpatory, which sounds great because it opens it up a little bit more. But then they added this ridiculous that it has this ridiculous part about how it has to have been done in bad faith. Okay, that's a problem because it's really hard to prove. Okay, but that's what the standard is. And so when Wisconsin was evaluating a case about destruction of evidence, they were saying just what I said before. They said, well, we're not clear, like the Supreme Court didn't make clear that one is more important than the other. So instead, what the Wisconsin court did is they took the rulings from both of the cases and put them together as one rule of law under the case law of State versus Greenwald. So State versus Greenwald, again, has two parts to it. It says you either have to show that it was apparently exculpatory, or in the alternative, you have to show that it was potentially exculpatory, but that law enforcement and that law enforcement destroyed it in bad faith. Okay, let me just see what I all have here. Okay, I just want to make sure when I get through these notes, I didn't want to read too much, but I do want to make sure I don't miss anything. And, you know, I got to give justice time to bark too. It's very important. Okay. So the apparently exculpatory one is going to be kind of hard to win because they're not. The bones that were found in the quarry at best were determined to be possibly human. Okay, that's not apparently exculpatory. Even if they could be proven to be Teresa's, that in and of itself is not exculpatory. That still doesn't prove that Steve didn't kill her. It just proves that everything the state said with regards to what happened to the crime is wrong. Everything they presented in front of the jury was wrong. And that's why it would be a violation. Okay, because, you know, you essentially just lied to the jury for the entire trial. And they didn't hear critical evidence that would contradict the state's narrative. Now, I know some people are trying to say like, oh, the state didn't really give a full narrative. They didn't spell it out that much. Okay, come on. Like everything about their case was about Teresa not leaving the property. Bobby's testimony was vital to them, and Ken Kratz said it himself multiple times. Bobby was the star witness who proved that Teresa never left the property. After Teresa was supposedly abducted, justice, the state never said anything about Steve taking her off property. They said he took her and put her in the garage. Well, they, you know, who knows what he did with her supposedly, but they couldn't prove sexual assault, so that's why they had to drop that. So essentially the next part of it is just that he took her into the garage and he killed her. And then the next part of that is that he burned her in his backyard. And he disposed of all her personal belongings in the burn barrel. Nothing of any of that suggests that they are saying she could have left the property. They even had Dr. Eisenberg testify about, you know, how the burn pit was the burn event area because, you know, if the bones would have been moved, they would have been broken and more, whatever, you know, all that. So you have some large chunk of bones in the quarry. So even Eisenberg's argument then would not work because according to her, those bones would have been way too brittle and they would have broke if he would have put them in a burn barrel and randomly dumped them out in the quarry while leaving other bones in the burn barrel and the rest in his backyard or behind the garage. Anyway, so that's why it's ridiculous to say that that's not the narrative that the state put forth. You know, they said nothing about her leaving the property, and that's why it's important. If these bones are proven to be Teresa's, somebody's got to investigate how they got there. You know, and then that's when you can bring in all the stuff that wasn't really brought in at the trial about the scent dogs and all that other stuff, you know, that was brought in that proved that she could have left the property, the thing that the state never wanted the jury to hear. Okay, so that's why it matters. So under Youngblood, where the standard is, sorry, got to deal with these headphones, where the standard is that the evidence has to be potentially exculpatory, well, clearly that qualifies then, because it doesn't have to say that Steve's innocent, but in order to get a conviction overturned, they have to prove that his due process violations were violated, and that can be just by the fact that the trial was fundamentally unfair. And a trial is fundamentally unfair when the state doesn't let the jury hear all of the pertinent evidence, when the state got a completely false narrative. Okay, so that's why it's not necessarily the results themselves could overturn the conviction. It's the fact that the results, if they turned out to be Teresa's, would result in that trial being fundamentally unfair and therefore a due process violation under the 14th Amendment. Okay. Now, when it comes to, I said that the fact that they're potentially exculpatory, that, like I said, that should qualify. But the second part is the bad faith component. How do you determine that law enforcement acted in bad faith? And this is where some of those arguments Kathleen was making really come in. Okay. The fact that, as I said earlier, you have the two attorneys that were involved in prosecuting the case. And and then one of them, again, was one of the pioneers of preservation of evidence for DNA testing. So he can't claim ignorance. Okay. He can't say like, well, I didn't know this could be important. Come on. Just, again, don't insult our intelligence. The fact that the testing was inconclusive. The fact that the testing was inconclusive, they didn't say that no information could ever be gathered from these bones. They were inconclusive based on the testing procedures that were available at the time. So again, it wouldn't be reasonable for law enforcement to think that, well, there's never going to be a DNA test that is going to get us any more information on these bones. Okay, again, Norm Gunn, okay, he could never say that in good conscience, ever. Say that he ever believed that technology could not catch up to where it needed to be to get a positive identification. It's also why Kathleen is arguing the fact that they gave these bones to the Halbach family just in itself infers that law enforcement must have believed they belonged to Teresa, because why would you give a grieving family animal bones? Why would you do that? Now, this is what people kept kind of bringing up to me about the first part of the statute. Well, law enforcement obviously believed they were the victims, and so it should qualify. No, it's not how it works. Okay, it doesn't matter what law enforcement may or may not, believed at the time they gave them away. They still are not identifiable to her scientifically, nor in a court of law. Remember, the court can only make rulings based on the court record. According to the court record, those bones were, at best, suspected human. So it doesn't work under that part of the statute, but it works under the second part of the statute and under this case law. Okay, she can still use those arguments, and they're still important. Because again, now you want to say, like, was it reasonable for them to give away bones that didn't belong to their daughter? Is that a reasonable thing to do? So therefore, like, why would they do it unless they truly believe they belong to Teresa? Now, you have to account for the fact that they may have lied. I mean, they may have lied to the Halbachs. They might have said they belong to Teresa. Just because we think it's crazy, that doesn't mean the Halbachs didn't accept bones that they knew didn't belong to their daughter. We just don't know it for a fact. And again, you have to deal with facts. Okay. But this is why, and I'll get to it more later, but this is why I say that this begs for a hearing. Okay. I mean, I'll get to that more, but that's the reason why, is because you can't just guess. You can't guess at what they were thinking. You can't guess at why. You can't guess at what the Halbachs knew or what they accepted. None of that is factual. It's just us doing a bunch of guessing based on logic, yes, but it's still not fact. Okay, so that's why the trial court is a fact-finding court. The Court of Appeals is a review court. Okay, so if you want to establish the facts surrounding the situation, it has to go back to the trial court, plain and simple. Kathleen also argues that the combination of both statutes, both the preservation of DNA statute or biological evidence statute and the post-conviction DNA testing statute combined together essentially informs or forms an intention of the legislature to allow this type of testing to be done on this type of evidence. Okay, she's just saying that, like, well, why do you have these rules? Why do you have these laws if they can just get rid of something that very clearly could still have been tested? and it could have been proven to be identifiable to the victim. Okay, the problem is that we don't know, we can't say for sure. And again, that's why it's only potentially exculpatory and not apparently, because the results of themselves, by themselves, we don't know what the results are going to say, and we don't necessarily know that the results are going to be, like I said, prove innocence, but they're important. Okay, they're very important to the trial that took place. And again, everything now is based on the trial that took place, not a bunch of stuff we learned afterward, not everything it is the record consists of what happened at the trial. So that is what everything has to go by. Okay, so going on from there, now this is another part of the motion.
Wait.
Okay, go ahead.
Okay, we have a question.
Okay.
Let me get to it.
Let me take a drink while you're asking.
All right. The guilters claim as long as they kept a sample of each evidence number that they're in compliance with the statute. Is there any truth to that?
No, because it depends what's under the property tag number. I mean, they could have collected a bunch of bird bones under the property tag number and one human bone, and that doesn't give them the right to give away the one human bone and keep all the bird bones and say that they follow the rules under their statute. No, it's very bone specific here. If there's anything that was ruled previously that it was suspected to be human, then that is the question. I don't care what else they gave away. It's the ones that were suspected human. That's what needed to be kept, because there were several suspected human bones, and they all would need to be tested, because you might not get results from one of them, but you might get results from another one. Because of the condition of the bones, you really want to have all of them to test, because there's just not a lot to work with. So no, that's not true. They don't have to keep just one thing in a property tag number. There were several property tag numbers where they collected like 6 swabs of different areas. That wouldn't mean that they can get rid of all of them except for one, the one they felt like, what they do, eeny, meeny, miny, mo. No, you can't just, okay, anyway, I think you get my point. No, not true. Sorry. I get very sarcastic sometimes, sorry. Is there anything else?
Just a little.
Well, I mean, it's kind of a ridiculous notion.
Okay, so the other one is, are there any new tests that have come out that the bones that could prove that the bones that they have are for sure Teresa's?
Well, that's what they're alleging with this rapid DNA test. They obviously can't say for sure without seeing the bones for themselves and doing the testing for themselves. That's kind of one of the problems with this, is that you don't know what results you're going to get. But the thing is that you should be able to try. That's the spirit of the testing statute. Now, the thing about the rapid DNA testing is not only is it a quick test, you can get results in less than 2 hours, but it's done completely differently. And so it's more sensitive. And so that it can get a DNA profile off of something that traditional testing might not get, because of this increased sensitivity, and it just works differently. It doesn't test the same types of markers. I read an explanation of it, and I'm not going to go into the technical details because I can't remember them close enough to feel comfortable quoting it. But I know that it used a different type of system for extracting a profile of the DNA, and one that is supposed to be more reliable and more sensitive, that you can get DNA off of things that you wouldn't normally get from traditional methods, and it's faster. So we obviously don't know for sure if they could get the results, but this is the testing that is kind of the next in the step of evolution of DNA testing. And so it would probably be the best bet of the technology that's available. And just regular old DNA testing has advanced greatly since 2005, 2006 too. So, but this is the only test that I think that we know for sure is known to be able to get a DNA profile off of biological material that wasn't able to be extracted from typical laboratory methods. Okay. Anything else?
All right. So if the bones are given to her and they find out they're not Teresa's, I have to get back to the question. Hypothetically, if a hearing happens and the said bones do get tested and they're not Teresa's, does that completely wreck the state's case?
The state's case? If they're not Teresa's, it wouldn't do anything to either side of the case. Nothing would change. That's all. That's the thing. That's why it's kind of a one of those things that's a no-brainer to do the testing if you can, because it doesn't hurt Steven anyway if they don't turn out to be Teresa's. It can only be helpful to him.
All right. How about, is there a new test that would give her access to the RAV? I'm not sure what that means.
It's for the RAV. It's not that there's not technology to get it tested. It's that she doesn't have access, and she won't until the case is back under the jurisdiction of the circuit court. So that's something that's not ruled out. I mean, they had agreed to do the testing before, for the RAV. Of course, they agreed to do the testing on these bones too before. So who knows? But yeah, that's something that they agreed on already. So there's nothing to say that they won't agree to it again. It was just because the judge ruled early that they weren't able to do it because there was no procedural mechanism at that point to get the testing done, because it has to be ordered by the circuit court. And as far as the circuit court's concerned, this case is technically closed. It's moved on to the appellate court. Anything else? Or should I move on? Okay. So one of the other.
Wait.
Did you do that on purpose?
No. Okay. One more question.
Okay.
When Fallon told KZ that he would allow bone testing, knowing they didn't have the bones, is there any legal violation?
No, not necessarily, because I don't want to go too much into it because I went to it a lot in the last video. But I mean, the case law has suggested that even if the evidence was in the custody and then the defense requested it and they destroyed it after they requested it without giving to them, it's still been proven not to be considered to be in bad faith. Go figure. So no, that wouldn't be bad faith at all. It wouldn't. I mean, it should be, but it wouldn't be considered based on the existing cases where something like that has been brought up. Like I said, if they can actually request it and the state knows they requested it and they destroy it instead of giving it over to them, and that's not considered bad faith. I mean, it's what is, Now, there's one thing I do want to point out is that all we really have are these the CASO files, this CASO report. It's not very clear. Okay, in the body of the CASO report, it makes it sound like they just pulled out all the bone fragments from the tag numbers and handed them over to the Hall box. In the beginning of the report, it says that they pulled out the human bones to go through them to see what could be given away. So they're giving two very different impressions. So we don't know for sure that they gave them any of the suspected human bones. Again, this is why we need a hearing, because we need to find that out. Like, we just have a report that I think we all are well familiar with their report writing skills and how not thorough they are. I think we've been making a lot of assumptions because it's the same tag number and because of the way it's worded in the body of the report where they said they removed the bones from that tag number and gave them to the Hall box. That's what it says. So that sounds like they gave them everything. But like I said, the beginning of the report suggests something possibly different. So there's also that possibility too. I mean, we still don't know exactly what was turned over. Now, again, if they were non-human, I still don't know why they'd be giving them to the Hall box. But again, we don't know. That's something that's why we need to get answers. And you can't get answers in the appellate court. It has to be in the trial court.
Yeah, Allie just said, I think they mean if the bones came back to not be Teresa's, would it hurt the state's case since they're presumed to be from the murder?
No, because they already knew that they existed during the trial and it didn't hurt the state's case then. It was already established during the trial that they existed and that there were some of them may have been suspected to be human and it didn't hurt their case at all then. So no. And honestly, the state's case isn't what you have to worry about because they're not on trial. Neither Steve, actually. I mean, you have to prove that something pretty significant went wrong, and that wouldn't be it because that already happened.
And then, is there any way that KZ can assure that the remaining bones are preserved?
Well, yeah. I mean, first we need to find out what they have. And if they do still have them, she can make a request that they make sure to preserve them. Yeah. Again, though, case law shows that even if she makes that request and they somehow accidentally get destroyed, it's just negligence. It's not bad faith. Yeah, I hate the law just as much as everybody sometimes. Okay, so.
And then how long can they stall without a reply? The
Who?
state. The state.
They already responded. I'm confused.
Yeah, I don't know. I'm just reading the questions.
Oh, okay. Yeah, the state already responded. We just don't have it. So I'll get to that in a little bit.
Carry on.
Okay. You sure now this time? Okay.
I'm muting and I'm not unmuting.
Okay.
So you're done with your next section.
Okay. Well, this section is not very long. It's just, it was still a part of the last section, but that's okay. Okay. So the final part that I want to talk about as far as the statute goes, well, it's actually not the final part. I got a whole nother section about the statute, but one of the arguments that Kathleen is making, and she focused a lot on it, was the fact that law enforcement was not allowed to dispose of the bones without giving written notice to Steve and Brendan. Okay. Again, it's not what the statute says. And this is the point where I say, like, don't blame me. Don't shoot the messenger. I didn't write these things. I'm just telling you what they say. Okay. So when we don't like them, it's not my fault, I swear. Okay. So the problem is, and this came up in my group yesterday, and I didn't even realize that people were reading it this way until somebody pointed it out to me. And then that's when I said, God, our statutes are dumb sometimes with how they're written. It's written in a kind of circular fashion. There's circular references in statutes, and they're always written this way, and that's why they get confusing. Oh, there's a lot of reasons why they get confusing, but that's one of them, and that's what the issue was here. Because, again, sub 2 starts by saying, except as provided in sub 3, if physical evidence that is in possession, blah, blah, blah. And so somebody suggested, well, could that possibly mean that sub 3, which is the part that says that they have to get written, or they have to notify whoever's been convicted of the crime, is it possible that that is meant to be taken first before they do this narrower scope of saying it has to belong to the victim? And no, that's not what that means. When it says except as provided in sub 3, what they're actually saying is, unless you gave written notification as is directed in sub 3 to dispose of something, you should be keeping this blah, 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 blah. That's what they're saying by that first part. But since they're referencing something that comes after, it gets a little confusing. But in sub 3, they also reference sub 2. So you can't really just switch them around because they're circular. So, but that's all they're saying with the part that says except as provided in sub 3. They're saying, like, unless you took the proper protocol or took the proper steps to notify people, and that's how you dispose of it, other than that, then you need to preserve it based on these guidelines. And so I was trying to show people that the written requirement still only applies to whatever they are supposed to keep under sub 2. And again, that is something that's from the victim or something that could reasonably be used to exculpate somebody. Oh, I'm having trouble with that. I say that word all the time, and yet having some difficulty today. Okay, so it's not, as some people are reading it, that they have to give written notice to dispose of any biological material. No, that's not true. Again, they only have to give written notice if they're going to dispose of something that they're not supposed to get rid of based on the qualifications in sub 2. Okay, and we know this because 2M says that law enforcement agency, again, it says they shall retain evidence to which sub 2 applies. Okay, so again, they're just reminding you that they have to retain evidence, but not just all evidence to which sub 2 applies. And then in 3, sub 3, which is the one that talks about written notification, they're saying a law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in sub 2. Okay, again, they're not specifically saying that it falls on, like, it's only materials that qualify under sub 2, but since they're mentioning the time limits mentioned in sub 2, clearly they're only referring to things that are in sub 2 and not everything. Okay, so that's another thing that has been really, like, confusing to people. because sometimes it sounds like that they were supposed to give written notification for disposing of anything, and that again is not true. They were supposed to give written notification if they disposed of anything that qualified under sub 2, which were those 2 areas that I talked about. And I did talk to Steve, and he said that no, he was never notified of them trying to destroy anything ever. So, okay, so this is going to lead me to the next part, because why is this so restrictive like this? Okay, and the answer is that it's really not, or it's not intended to be. Okay, and so this is going to lead me into the discussion about the Avery bill. Okay, now are there any other questions quick before I go into the next section? Because I need a drink.
Sure, take a drink.
Yeah.
One question that's been asked a couple times is if any of these documents or any or of all reports in Brendan's case can be looked at to be used for Steven's case.
If it's discovered that it's considered a due process violation that they disposed of them, then yes, it should be, because it shouldn't matter the circumstances of the trial. Okay, it shouldn't matter. The whole question is, were they allowed to dispose of them? If that question is no, it applies to both of them, because it's the same evidence for both of their cases, and they were both convicted using that evidence. Now, it doesn't matter. It does not matter if the evidence was used in trial. That's another thing I have to point out, that the evidence does not have to have been used at the trial. Okay, it says any evidence collected during the course of the investigation. I do need to make sure I specify that. Because people say like, well, the pelvic bones themselves weren't brought up at Brendan's trial, or something, whatever. And I'm like, it doesn't matter. Anything that was collected in the course of the investigation is pertinent. It doesn't have to have necessarily been presented at the trial.
Okay, will you be answering this later, maybe? What do you suspect the state will be arguing in their response?
Yeah, I'll get to that. That's coming up. Okay. Anything else?
And I think that Travis, thank you, Travis, has been answering just about everything else.
Good. Okay. Thank you, Travis. Okay. So I want to move on because we're already like 40 minutes in. Oh, God. Why does this go so fast? Okay. Because I swear I never planned on these being long. Okay. So the Avery bill. Okay. So here is the story. When I was reading the motion for the third, fourth time, in the beginning, or closer to the beginning of the motion, in the first 7 pages or whatever, Kathleen cited the current statute, which has the qualifier that it has to be from the victim, or it has to be or could reasonably be assumed, or could be reasonably thought to be possibly exculpatory. That's in the statute she cited. Later in the motion, especially when she's talking about the whole bad faith issue and everything like that, but a lot of the case law stuff, she keeps referring to the fact that they were not allowed to destroy any biological material. And I'm not going to lie, it bothered me. I was like, why does she keep leaving out that part? Because it's kind of an important part of the statute. So I found the law review article where Kathleen actually got the bulk of her argument came from this law review article. And I was reading the article, and the author of the article was doing the same thing. And I was like, okay, wait a minute. Like, I expect lawyers to leave out words that could sometimes be detrimental to their case. It happens. But law review articles, not really. So I was really confused. Then I looked at the date of the law review article, which was 2004. And the one thing, for some reason, that had never occurred to me to look into was the actual history of the statute. So when I looked, it had been amended in 2005. I was like, oh. I looked at the original statute, and sure enough, the original statute that was enacted in 2001 said that any biological material that had been collected during the course of a criminal investigation had to be preserved, period. All of it. Okay, none of this, had to be from the victim or had to be reasonable to think it could be exculpatory. That was not included. It was just any biological material collected during the course of the investigation that led to a conviction had to be preserved. So I was like, well, why did they change it? Why did they make it more restrictive in 2005? And so I looked at the history of the 2005 amendment. And when I clicked on it, the first thing I saw was 2015 Wisconsin 60. And I mean, I know what that is. I was just like, you've got to be kidding me. There's no way Steve's own bill made this statute more restrictive. It just can't be, and I just sat there like, and it was just this craziness again. Like, it seems like even the littlest things or even the weirdest places you find things that just are so crazy. I was like, I cannot believe Steve's own bill could end up screwing him on this statute. It's just so unfair. And so, I mean, my heart kind of sunk, and everybody that knows me, like, I was just like annoyed and frustrated and angry, and I just started drinking wine, and then I couldn't be, nobody could talk to me after that. Sorry, because I was a little loopy, but I was still answering questions. And, but if I hadn't been drinking, I probably would have been a little bit more logical thinking about it a little earlier on. But I posted it as, you guys will not believe this, type of thing. It was, to me, I called it tragic irony that the statute was all encompassing until the bill that Steve's name was on was enacted, and then that made it more restrictive, in which case now gave law enforcement probably gave them the permission to destroy the evidence that could now exonerate him. Okay, as people say, you can't make this stuff up, so. But what surprised me is when I posted it, first off, a lot of people just didn't get the point of my post. I wasn't posting new information. I was saying, can you believe this? And yet it led to all these questions about this part of the statute, about it having to belong to the victim. And it surprised me because I discussed it. I had been discussing that since before even this motion was filed, when she first did the rapid DNA testing. When the first mention of the bones was, I had said that. I said, well, the statute says that it has to be from the victim or, blah, blah, blah. It doesn't, it's not everything. And Steve and I even argued about it. And then I later, after I found out about the amendment, then I realized why Steve and I were probably arguing about it, is because when Steve really knew the statute, it was all encompassing. He probably doesn't remember that part about it being added, even though it was part of the Avery bill. Who knows if he really knew everything that was in there. I don't really know. I'll talk to him about it at one point. I don't want to tell him about this particular part, though. It's a burden he doesn't need. Okay, it's like, I don't, and anybody that would tell him that, it's like, then I have to question your intentions, because why would you ever do something that could be potentially even more hurtful? Like, no, he doesn't need to know his own bill may have made this harder for him. Okay, he does not need to know that. So anybody listening that talks to him, please just use your head. So I would like to talk to Steve about it, but I don't want to talk to him about it in reference to this, because I don't want to make him feel worse, or make him, he just doesn't need to be worried about stuff like that. Okay, so anyway, and the bill was introduced, again, it was part of the bill that Steve had his name on. So, I mean, it was introduced into the legislature in September 2005, so before Teresa disappeared. So before anybody starts screaming that this was planned corruption, and the bill was introduced before the crime even happened. So, and I can actually explain why they did this, because that was one of my first questions. It was like, why is a criminal justice reform bill making this statute more restrictive? It would hurt somebody. And the answer is, it was never intended to. Okay, when you think about it, adding the qualifiers that it has to be from the victim or have the potential to be exculpatory is actually pretty all-encompassing. It actually covers most situations you would think of. This particular situation is so unique and so specific that if I had to guess, I'd say that nobody foresaw this type of situation when they wrote it. Okay, because anything that could exculpate the person, like, again, I'll use the pubic hair in the 85 case. That doesn't belong to the victim, but that would have been required to be preserved, because obviously that could either incriminate somebody or it could exculpate somebody. So it's not like they're saying only things from the victim. Anything that could prove that somebody else did it, or that could prove that the person who's in prison didn't do it, needs to be kept. So it's still very all-encompassing. this particular set of circumstances kind of just falls through the cracks. And again, I can probably guarantee nobody thought of this scenario when they wrote it. So then you have to go to, well, then, but still, why did they amend it? Why did they change it? And there's actually a really good reason why they amended it. And that is because if you say that they have to keep everything, all biological, samples that were collected during an investigation, that means they would have to keep everything. And that includes like DNA swabs that are used for comparison or exclusionary purposes. Once you use those swabs and a profile is created and is on paper, you no longer need to keep those swabs. And in 2001, when the statute was enacted, they probably didn't, again, foresee how important DNA testing was going to be and how vast it was going to be and how many potential DNA samples were going to have to be taken in the course of a criminal investigation. So by the time 2005 came around, they were probably like, we're going to need to buy a whole lot more refrigerators if we're going to keep up at this rate. So that's why they did away with they have to keep everything so that they could get rid of the DNA specimens or samples that didn't have any probative value. Again, not foreseeing that there could be a situation like these bones that is like a gray area. They also did it, and again, why is it part of a reform bill? To protect the public. We know very well that DNA can be planted from a swab. So could you imagine if they were able to keep everybody's DNA swabs from every investigation they ever did? How could the public, it protects law enforcement too. I mean, how would the public ever feel like, everybody could be able to, or a lot of people could present a planting defense if police kept custody of all these swabs. You can't plant DNA from a piece of paper. Okay, so that's why it's actually better for everyone that these swabs are destroyed. And this is another reason why I know that they don't notify everybody, because I guarantee you they don't notify everybody every time they destroy their DNA swabs. Who knows though, maybe they do just to let them know so they don't have to worry about them still being in custody. But I don't think they're notifying them for the person to tell them not to do it. But this is why I think also that they added that second part of the statute where they said that, you only have to notify them if it qualifies under sub 2. Because again, they're not going to want to notify everybody they've taken any kind of sample from. Or there's other types of biological evidence. Travis was joking around about a sandwich. Like if somebody's eating a sandwich, like, do you have to keep the sandwich for 40 years? No, of course you wouldn't want to, but whatever probative value the sandwich had, you would have in a report and then you could get rid of it. So that's why. And it actually makes a lot of sense. It's just that it's unfortunate that once again, as is always the case, Steve's case is the weird one that just doesn't ever seem to quite fit into the norm. Just doesn't in any way ever. And it's pretty weird. So anyway, so that was the whole reason I posted about it. I posted about it because I just thought it was very ironic and in a terrible way that his bill changed things. But, once I stopped drinking the wine, I was able to realize that, it's not as terrible. It's not good for Steve in this circumstance, but it's not a terrible reason that they did it. They did it for a good reason. And it had for a couple good reasons. Okay, so anything? Any questions? I can move on. Okay. So here we go to the next part, the possible arguments the state could be making. Obviously, everybody knows courts were closed. I think I said that before. So the clerk's office was closed. We couldn't get a copy of the response. I have not talked to Steve today. So I don't, I haven't talked to him, so I don't know if he knows what it says yet or not. So no help there either. But, my first thought was like, what argument can they possibly make? Because, it's kind of cut and dry. It's like if they don't have the bones and it has to be remanded. So there's a couple things. Number one is if in their response, they say that they have custody of those bones that were requested and they have affidavits proving it, well, then obviously it wouldn't need to be remanded and this motion would go away. Because that's the whole point, is that they don't have these bones, or so we don't think they don't have the bones. But if the state can prove that they do and that those reports are just terribly written, well, then that would be one reason why they would have to respond and one reason why it may not be granted. The other thing is that I'm sure nobody but me remembers this, but all the way back in 2016, when Kathleen filed her very first motion, which was to stay the pending appeal so she could do scientific testing, the state filed a response on that motion, but they didn't object to it. They actually corrected an error she made, which was, of course, but I mean, they just had to, put that in there. But their reason for filing the response was to say that Kathleen's motion didn't give any indicator about what should happen to the record. And so the state said, if you are going to grant the remand, we are requesting that the record be remanded to the circuit court for further post-discovery proceedings. So it ended up, their response wasn't bad at all. I mean, it was just saying like, hey, if you're going to do this, can you make sure you send the record back to the circuit court and not just do a limited remand, like what's what happened with the CD. So it's possible it's something like that too. I mean, as far as I know, nobody really knows for sure. The only other thing is they could be whining about another delay, which, I mean, they can whine all they want and the courts might not like it, but I mean, if there's a genuine reason why it's delayed, they can't really say anything about it. So then the reasons why, the reasons why it should be granted are pretty simple. It's, as I said, that the second part of the statute about whether it was, that the materials should have been considered reasonably potential to be exculpatory. God, I'm saying that in an awkward way. It was reasonable to believe that they had some probative value. Let's just go that way. That is a discretionary decision. Whether the state acted in bad faith when they disposed of it, that is a discretionary decision. The Court of Appeals does not make discretionary decisions without the trial court first evaluating it and making a decision on it. Okay, because again, the trial court is a trier of fact. The Court of Appeals is a review court. They review that judge's discretionary decision. And then that is their discretionary decision. But the trial court has to do it first. So the Court of Appeals can't just decide whether the statute was violated. They can't decide on their own whether it violated case law because they don't have all of the facts and they are not the court to determine the decision based on the facts. They are not the court to hear the facts. It has to go back to the circuit court. And that's why I said that, it pretty much begs for remand and begs for a hearing. Because how can you determine if law enforcement acted in bad faith if you don't ask them why they did it? Okay, you have to find out what bones were disposed of, why they gave them those bones. If they were suspected to not even be human, why did the Hallbox accept them? All of those things need to be determined, and you have to have a hearing to do that. So the only real reason for the court to deny is if it's, like I said before, with the state's argument that they can prove they have the bones in custody. Well, then again, the court would have no reason to grant the remand because it's a non-issue. The only other reason I could see the court denying, and this is an issue that Kathleen brought up in the motion, is that she's bringing it up now because this is a constitutional violation, potential constitutional violation. Constitutional violations have to be brought up in a 97406 petition, and they have to be presented when they're known. You can't wait until later and present it at that time because you'll be procedurally barred from presenting it. There is a waiver issue. Now, again, we are in a gray area here because technically it's been ruled on. Okay, so technically that petition is dead for all intents and purposes unless the Court of Appeals reverses it. So she wouldn't necessarily be procedurally barred from presenting this in a successive petition if she needs to, but she can't take that chance. And that's why she's saying that to the court. Like, I don't want to run into a waiver issue, so that's why I'm presenting it now. So if the Court of Appeals decided to say, we're not going to grant this now, but you can bring it up on a successive petition, meaning there would be no waiver issue, then they might possibly not grant it. I don't see why, though. I don't see why you would delay something that could be added to the current appeal. I mean, that doesn't make any sense to me to have to go through another proceeding when you can actually just go a couple months. But I'm just giving you reasons why it's possible they could deny it. But I still don't know how they can. Like I said, short of the state coming up with those bones, I don't know how they could. So, okay. Are there any questions from that? Okay, almost done. Okay, so here are the next steps. And this is why I was saying that, you know, Steve's not going to be released in 30 days unless something huge. Oh, you got something?
Yes.
Okay.
I needed to scroll down. Linda just asked, would that alone get a new trial?
Okay, which part?
I don't know.
I don't know which part, Linda. Which part are you referring to exactly? I'm babbling on about a bunch of stuff. You got to be more specific.
If she answers, I'll ask you again.
Okay. I said I'm almost done, sort of.
All
I
right.
have like 2 more sections.
Maybe you'll answer her question.
Yeah, well, this part will be quick because these are just the steps that need to happen.
Okay.
So this is why I said Steve is not going to be released in 30 days unless something like insane happens. Okay. He's not going to be released in 30 days. Why? Because there are a lot of things that have to happen, even just on this issue alone. The court needs to grant the remand. Okay. And then the Court of Appeals, when they grant the remand, just like they did with the CD, they will set the procedure for the remand, the time limits, when everything has to be done. They set that. Okay. So probably they would give Kathleen 30 days to file the motion. Okay. So that motion would be the motion to actually present the case in the circuit court. Because this motion is just telling the Court of Appeals why it should be remanded. The motion in the circuit court would be similar and have the similar arguments, but she has to present it to the circuit court. The state would get an opportunity to respond. They would probably be given 30 days. So she would be given 30 days. They would be given 30 days. Kathleen may be allowed to reply. Usually it's 15 days, and they don't always reply. Sometimes they allow it. Sometimes they just said nah. Then the judge, Judge Suckwitz, would decide based on the briefs whether a hearing was warranted. Okay, that shouldn't take too long to decide. Maybe a couple weeks, I would think. If a hearing is granted, it would take 2 to 3 months just to schedule it. Okay, and then they would have the hearing. Probably be maybe 2 days, maybe a 2-day hearing, I would think. After the hearing, the judge would have, usually they give 90 days, but on the last remand, I believe they only gave 60 days for a decision. So again, the Court of Appeals would set when she'd have to make a decision by. So 60 to 90 days. If she rules that it was a due process violation, Steve's conviction will be overturned. Okay, they violated his constitutional rights, and it's an automatic reversal of his conviction. Then the judge would give, and we should remember this from Brendan's case, the judge will then give the state a time frame in which they have to decide their next move, whether it's going to be to appeal the decision, to initiate proceedings to retry Steve, or just outright release him. Now, again, if Brendan's case taught us anything, they're going to appeal. So if the state appealed, my guess would be that they would probably consolidate it as a cross appeal with the appeal that Kathleen has pending. I don't see them making it a separate issue, but I mean, that's way down the road, and that's dependent on him winning. If Steve loses, then that issue should be consolidated with this appeal. And then the Court of Appeals would just review her decision like they're going to review every single other thing once we get to that point. And the briefing schedule would commence then again. You know, and chances are that the judge would give Kathleen another 35, 40 days to write her brief, and we'd be waiting till the brief was due again, and then hopefully not have any more delays. Because again, as you notice me saying, Judge Suckwitz is deciding this. We cannot get rid of that woman. You know, like, we have to get through this appeal one way or the other. Whether Steve loses or wins, he can get rid of this judge once and for all after the appeal has concluded. Now, it's interesting, though, that what I said before is that the state requested that the record be remanded back to the circuit court. That can qualify as a remitter, which in that case, maybe she could get a judicial substitution. So that would be interesting to find out. I'm not sure about that because, oh my God, I have to fix these, sorry. Yeah, so that would be interesting to find out because the big thing about a limited remand is that the record never leaves the Court of Appeals. They're just sending it back temporarily. If you're sending the record back to the circuit court, you're giving them jurisdiction again. And in that case, she could make a good case from being able to make a judicial substitution. Again, it depends if the remitter would be filed. So that usually doesn't happen until finality. So I don't know. It would be at least maybe an option, a chance, I should say. Not really, I don't know. I didn't look into it. Let's put it that way. I haven't really looked into that specific scenario, but I will because now I'm curious. It just kind of came to me. Okay, so now the big question. I've talked about whether it should be remanded. Yes. Whether there should be a hearing. Yes. I've never talked about whether she can win it or not. If you watched my last video, you know that it's a long shot. It is. The one black letter area of the law says that it has to come from the victim. We know that that's not true. So she can't win on that. Everything else is subjective. It's a judge deciding whether law enforcement's actions were either reasonable or if they acted in bad faith. Nobody in Wisconsin has ever won on a destruction of post-conviction evidence case based on the statute. Nobody's ever won on a bad faith argument either. It's never been done. But Greenwald, which is the controlling case, was from, let's see, what year was that again? 94. The preservation statute wasn't enacted until 2001. So they're using case law that was 7 years before this statute was enacted. So yeah, there's never been a case like this one in Wisconsin. In fact, to make things even more depressing, there are only a handful of cases since 1988 that have been proven to be bad faith in the entire country. There were 7 as of 2007. I think there have been a handful more, but 10, maybe 12 times have the courts, out of thousands of cases, have they decided that law enforcement acted in bad faith. Essentially, it's boiled down to the fact that if law enforcement admits it, they get on the stand and admit they did it, they get back at them, or they did it, with some animosity. Okay, then it's bad faith. That's literally almost the only circumstance in which they've granted. Everything else is negligence, incompetence, and that doesn't qualify, which is unfortunate. And there is no case in Wisconsin that has been won in a violation of the preservation statutes. There actually, as everybody I think knows by now, there actually are no remedies provided by the statute. So even if it's violated, court doesn't have to grant relief on it. It's unfortunate, but it's true. I mean, it definitely does nothing to promote justice, but I mean, no remedy is listed. So it's up to the courts to decide what they want to do. What was I just going to say about that now?
Well, let me pop in with a question then.
Okay.
What about showing that the narrative doesn't work?
Again, that doesn't matter. That all goes back to the trial, and that's not really a place where you can find a violation just in that alone. I mean, because what is the constitutional violation? That's why you have to have a specific claim, like a Brady violation or a ineffective assistance of counsel claim, or in this case, a due process claim. It has to be more than just a very general, that was what was fought at the trial. The defense tried to argue that their timeline didn't work, their narrative didn't make sense. The fact that why would somebody kill her in the backyard, but then put some of the bones in the burn barrel? Why would he do that? That was all part of the trial. So.
All right, another question. If this motion goes away, does KZ get another 30 days to file her brief? Will the COA allow her to tie up her word count, or to up her word count?
Yeah, that's what I said last time when she did the CD. They gave her 35 days, and so to file it again now, February 1st. So if it was to be remanded again, and then it ended up going back to Court of Appeals, they would give her time again to adjust her brief accordingly to add anything that was necessary from the results of the remand. Now, if they don't remand it, she shouldn't need more time because she can't add anything. Okay, so anyway, what I was saying is that in order for Steve to win, I said they have to prove bad faith, which good luck. It's a huge hill to climb. But I mentioned, again, watch my previous video. I know it's really dry, but I mean, there are some good things about like where the direction is going as far as the courts are concerned. Some judges and some courts have already expressed displeasure with this standard under Youngblood and the standard of bad faith. It doesn't sit right with them. And one of the judges is one of the judges on Steve's panel in the Court of Appeals. So that's good news. It's like one of those things that this particular issue, which has never been decided, not in a published opinion anyway, needs to be addressed. And it seems like the courts have been avoiding it. Like they are avoiding dealing with this issue because of the potential ramifications. Anytime they make any type of bright line rule on the preservation statute about a remedy, or they change the bad faith, loosen up the bad faith requirement, they're opening themselves up to a lot of post-conviction motions. And they have to really be sure they're ready for that. That shouldn't be the reason why they don't do it, but that's a big reason why. I mean, otherwise, why do you explain there have been no cases that have won in this many years? None. And not many across the nation. You know, like as of the law review article that Kathleen was referring to, there still had been no statutory, no wins under the statutory innocence laws by the preservation statute laws anywhere in the country. Now, I don't know if that's still true because that was 10 years ago. You'd have to think there'd be at least one, but there's not many, that's for sure. And there's definitely none in Wisconsin. So the courts are kind of at that point where it seems like they're ready or close to being ready to do something about this. It's just like how we discussed about Brendan's case, how the case law is outdated because they haven't decided a case about confessions or juvenile confessions in 50 years. We know more. We know there's more social science. There's more, evolved about false confessions and juveniles, that law needs to be updated. Well, the same is true with the law under Greenwald. Again, it was established 6-7 years before the statute was enacted to preserve evidence. We know so much more about the importance of scientific testing, the importance of DNA technology or testing, and how technology can advance. Even 20 years from now, people can be exonerated. So they know so much more about the importance of DNA and the importance of post-conviction testing that they can't keep basing it on case law that actually wasn't even established to deal with post-conviction evidence. It was established to deal with pre-conviction evidence, and they just said, well, it'll cover post-conviction as well. Well, again, things have changed a lot with all of the exonerations. So at some point, the court has to stop avoiding it and say, we need to address this issue because this is an outdated law. Okay, the case law is severely outdated on this issue. So, I mean, this could set a precedent. So, there's no saying they can't win that way. Now, the final thing I'm going to wrap with is that one of the questions some people will be saying is like, well, if she, it's such a long shot, why would she bother? Why is she delaying it again? Well, first off, she has to. Okay, because it is a potential due process violation. Also, because of the potential waiver issue that would come up if she didn't present it. So those are two very good reasons. When I said in the beginning that even a loss can be a victory, this is why I said that. Kathleen may know that history is not on her side. Judicial history is not on her side on this issue. But one thing that is pretty consistent is that hearings are granted. So even if she thinks it's a long shot that she will win, she's got to be pretty sure and pretty confident that she'll get a hearing. Who knows what can happen with a hearing? It's still a win just to get those guys on the stand, just to get somebody on the stand, to get people talking. And that could also have the added benefit of somebody slipping up and saying something that they shouldn't have. That's exactly how she won Ryan Ferguson's case. The DA got up on the stand during the hearing and she lost that hearing, but based on what he said, she was able to uncover another Brady violation, and that's what got Ryan Ferguson out. So she, more than anybody, knows that just getting a hearing for anything can open up new avenues. And so, like I said, don't always take things on face value when it comes to Kathleen. She may not think that this could be easy to win, but that might not be the ultimate motive. The ultimate motive would be like getting those guys on the stand and getting them talking, first. And she's proven it. She's done it before. She's gotten several times. She's gotten people on the stand and gotten them to say things that hurt themselves, incriminated themselves. So yeah, you guarantee she can be thinking that's a possibility. So again, that's why I said that even though, so even if the hearing goes against Steve, you never know. It can still have a benefit, and you can still have a victory come out of that. So that's why I said that. It's like, even though sometimes it seems like kind of a lost cause because, there's not a lot of winning with this type of argument, trust that, she's always got a plan. She's always got a backup plan. So anyway, okay, so that's about it. So now, questions. Anything you guys want to ask? First of all, does everybody understand? Because my whole goal here was to try to finally make this stuff easier for people to understand, that they could grasp it. So please tell me I didn't that much. I would be disappointed if people still didn't understand, because I was answering the same questions over and over and over again. So I hope I did that much.
I think you did.
I know, but you always say that.
Okay.
You hear me talk about this enough, so you better get it by now.
Who can she call in the hearing?
Anybody that was involved with the disposal. So Hawkins, gone. Fallon. Who else? The evidence custodian, was that Hawkins? Anybody that was involved. The Hallbacks. She can call the Hallbacks and find out like why they accepted these bones if they weren't supposedly Teresa's, or ask them like, were you told these were Teresa's? Did you understand they weren't? So yeah, Hallbacks can actually be called as well. Not saying that people, obviously the public's not going to enjoy that, but too bad. She can do it.
Okay, can a Denny suspect be named at the hearing?
No, this isn't a Denny hearing. The hearing will be limited to the circumstances surrounding the disposal of the bones, period. That's it.
That's all I've got.
All right, last chance. Oh, that wasn't too bad then.
No.
We're good? I'm sure that a lot of people are going to watch this on a rewatch. So yeah, so if you have questions later, just post in the comments. I am not good about checking YouTube yet. I have not gotten used to do that. Remember that if you are on Facebook, you can always still join my group, Basically a Lawyer. Just search for that on Facebook. And that's where I'm talking about this stuff all day long. Again, it's strictly for legal issues though. Don't start posting a bunch of stuff about general case discussion. That's what the other groups are for. Mine is strictly for about trying to clear up these legal things so that people can understand them. Other than that, that's really about it, I think. So, okay, so I'm going to wrap it up. And thank you, Angie, again, for helping out with the comments. Hopefully it wasn't too much trouble. Thank you to Jamie for moderating, even though I think you had some troubles with the link. But
and thank you for Travis for recapping everything you said. It was very helpful.
Yeah, Travis, I'll thank you when I read the comments. So, but thanks to Travis for being there and answering questions as well. I appreciate it. Appreciate the help. All right, so I hope everybody understood everything, and I hope it was helpful. And if it was, leave a comment so I know. But otherwise, have a good night.
Bye.